Good day, and welcome to Epstein Becker Green's webinar, What Are My Risks as the Telehealth Provider, part of the Telehealth and Telemedicine Crash Course webinar series. Before we begin today's presentation, please be informed that today's webinar is being recorded and the participant phone lines will be placed on mute throughout the program. In approximately 2 to 3 business days following the webinar, Epstein Becker Green will communicate the availability of the webinar recording and access to the PowerPoint materials. We are pleased to have a fantastic speaker today. Francesca Ozinal is an associate in the Healthcare and Life Sciences practice in the Washington, D.C. office of Epstein Becker Green. She focuses her practice on such areas as fraud and abuse, federal and state regulatory and compliance issues affecting a broad range of healthcare stakeholders, litigation, government investigations, and due diligence. Additionally, Ms. Ozinal is a member of the Telehealth and Telemedicine practice at Epstein Becker Green. At this time, I'd like to turn the webinar over to Francesca Ozinal.
Great, thank you for that introduction, Whitney. And thank you for all the participants for joining me today. So we're going to discuss malpractice issues that telehealth providers face. Very little information exists on the extent of malpractice liability in telehealth at this time. There have been a handful of telehealth-related cases, but the results are often sealed. However, as telehealth becomes more widespread and available, questions of medical liability will undoubtedly arise. Medical malpractice carriers, telehealth providers, healthcare entities, and other telehealth stakeholders will need to be able to identify and address the issues in the future, as this, for the most part, is uncharted territory. So that's why we're here today talking about these important questions, 3 of which I'll focus on today. So first, we're going to discuss some of the unique malpractice issues that a telehealth provider faces. Then we'll talk about some of the jurisdictional issues, and then we'll conclude by talking about how telehealth providers might be able to limit their exposure to liability. So potential liability for mishaps in patient care, whether as an individual provider or as a member of a larger healthcare entity, is an issue that's definitely on the mind of every healthcare provider. But telehealth may increase exposure to potential malpractice liability for healthcare providers. The legal principles that govern professional malpractice law were largely developed, I'm sure as you can imagine, during a time when physicians and other providers only saw patients in person, so physician-patient encounters that occur via telehealth raise a number of novel malpractice issues. So diving right into this first slide, I'll start with licensure. Licensure is perhaps the largest liability exposure for providers. Many liability policies exclude coverage for a claim if it's proven that the provider was not licensed in the same state where the patient received care. This, of course, is an issue that's unique to telehealth, given that doctors are providing care at a distant site, often in another state than the patient. There are many scenarios in which a patient could cross state boundaries during a telemedicine exchange into a state in which the provider is not duly licensed. Let's think about an example. Consider that a patient might be on the phone or through video consulting a provider while they're in the car driving, starting in Maryland, but then they cross into Virginia prior to the consult being over. If the physician is not licensed in Virginia, he or she could open themselves up to liability. Licensure is also a major concern in international telemedicine. In many countries, healthcare providers are not permitted to provide services unless they hold a valid license or registration in the country or local jurisdiction where they're providing such services. Another issue on this slide you'll see is technology and privacy. So telehealth technologies such as computers, iPads, tablets, cell phones, web cameras, and many others can falter during the course of treatment, and this can impair the evaluation and treatment process and obviously put patients at risk. For example, if a distant site provider is called upon to evaluate and treat a patient in an emergency situation and there's a transmission outage that takes place, the patient could be seriously harmed, resulting in liability for the providers involved. The risk of misdiagnosis is something to also consider, and it can occur if the telehealth technology is not accurately relaying data about a patient. For example, a patient might not set up video technology correctly on their side, and then an image that they're trying to display of their skin is not accurately depicting all the features of a problem that they're trying to send to a dermatologist. So this could result in misdiagnosis on the dermatologist end. Or the problem could be that the dermatologist didn't set up his or her video correctly, or the monitor for some reason is not displaying the lesion on the skin correctly because of the resolution issue or many other problems, and so this could also result in misdiagnosis. The problem could arise from the transmission of the technology. Consider that in the process of transmitting a live feed, the picture could be transcoded into a lower resolution, leaving out certain details of the image, and the dermatologist might miss a crucial feature of the lesion and then misdiagnose the condition. Telehealth technology also facilitates the generation, transmission, and storage of large volumes of electronic health information, which carries certain significant risks. First, the potential for unauthorized disclosures of PHI because the patient is not physically present. And then second, the potential for data security breaches when using telehealth technology. Relatedly, unlike in a traditional in-person encounter, when the patient and the physician are in the same room, authentication problems can arise when the physician and patient are at a distant site and interacting via some type of technology. The doctor might not know who's on the other end or have some confusion, and this could result in misdiagnosis. So moving on, with respect to scope of practice, the ubiquity of the internet blurs what it means to affirmatively act to diagnose or treat a patient. If a physician merely emails a patient with some advice, has the physician established a valid provider-patient relationship? What if a physician posts a message on an online message board in response to an individual's inquiry? Consider this. When two physicians use technology to consult with each other about a patient, but without the distant site provider examining the patient first, has the consulting physician established a valid provider-patient relationship with the patient such that the patient can bring a malpractice action against the distant site provider? All of these different physician-patient relationship questions are important to consider because a plaintiff involved in a malpractice suit has to be able to demonstrate that the physician owed a duty of care to the patient, and the physician generally only owes the duty of care to the patient when a provider-patient relationship has been established. It may not be clear whether this relationship has been established due to the absence of physical contact when there is a telehealth encounter. These are just a couple of the unique scenarios providers face when providing care via telemedicine that could open them up to liability, but as you can see on the slide, there are others. There's telehealth-informed consent issues, challenges around supervision when practitioners are using different types of technology, scope of practice. The definition of practice of medicine is changing as providers begin to use more advanced technologies in telehealth, practice standards and protocols. There's continuity of care issues because telehealth is more episodic in nature and more physicians can be involved in the encounter. There are a lot of issues to consider as a telehealth provider. Moving on to the next slide, jurisdictional issues. So further compounding the issue of professional liability for telehealth providers is the dearth of authoritative guidance that exists in this area, as I said at the beginning, but questions do arise as to where jurisdiction can be established when the physician and patient are located in two different states. So some of the questions that telehealth providers need to consider are the following. Can patients exercise jurisdiction in their home state over physicians located in another state? How about when the physician's in another country? Must the plaintiff file suit in the state in which the physician is physically located? What about which state substantive law applies when the physician and patient are located in different states? These are all the types of questions that courts might consider in the context of a malpractice action involving the provision of telehealth services across state lines. To dive a little bit deeper into this, healthcare entities and providers can't just assume that the laws in the state in which they're located are the ones that are going to govern and that they can, they'll be protected by those laws. Courts are likely to apply the laws in which the healthcare services were rendered, but they may apply the law where the patient lives. Where there are material differences in the laws the litigants seek to apply, the choice of law may be a substantial factor in determining the outcome of the case. There's some critical laws that there's some state laws that are critical for providers to know in order to insulate themselves from potential malpractice liability. And a couple of those include standards of care, scope of practice, establishing the physician-patient relationship, informed consent, licensure. All these laws can vary by state, and so providers have to be aware of where where they're practicing, and what laws might govern, and consider these jurisdictional issues. I wanted to highlight a case that came out of the New Mexico Supreme Court recently. It was a malpractice case, although not specific to telemedicine, called Montaña versus Freza. Some of these choice of law questions were considered when the court was trying to decide should they apply New Mexico law or Texas law. It was a long case, but I do want to highlight that importantly for the growth of telemedicine, access to cross-border health care for individuals living in rural parts of New Mexico was a consideration in favor of applying Texas law so that patients living in rural areas with a shortage of doctors, particularly with specialists, particularly the shortage of specialists, so they could gain access to the care through the providers living in Texas. So it's a good example of courts, considering these different jurisdictional issues when applying the law when a physician and patient are located in different states. Okay, next slide. Thank you, Whitney. So we've sort of gone through this doomsday scenario. There are all these risks out there. So what should you do as a provider? Well, it might seem obvious, but telehealth providers need adequate and appropriate professional liability insurance. But policies vary widely, so that's why we're going to talk about the who, what, where, how, when, and why of liability insurance. So we'll start with the who. So both providers and the healthcare entity need to be protected, but they should do so on a shared basis. This is more cost-effective rather than having each healthcare professional carrying his or her own policy with different sets of individual limits. When should a provider purchase this insurance? Well, they should purchase the coverage at the inception of the business before patient encounters commence, or when providers start providing care via telemedicine. If a provider already has a policy in place that was issued at a time when they were just doing office visits, but then they decide later that they want to add video conferencing or some other kind of teletechnology, or they want to join a virtual network, they need to inform their insurance carrier that they're doing this. In fact, providers may have an affirmative obligation to disclose this and disclose these issues, and a failure to do so could result in a dispute with the carrier and a loss of coverage. Okay, so the how. How should you find the right coverage for you and for what type of care you're providing? Well, it requires careful due diligence on the part of telehealth providers. There are a lot of different policies out there, so you really have to read the fine print. Some policies cover certain types of distant care, while others just cover online interactions, sometimes for an additional fee. Some explicitly do not provide any coverage for distant services, while others are silent on this topic. As I discussed at the beginning, it is not uncommon to see coverage exclusions for treatment rendered by an individual who fails to obtain the proper professional licensure in the state or locality in which the treatment was provided. If there are any exclusions in your current policy that you would like to remove, you can often do that by endorsement. If this all sounds daunting, rest assured you can engage an insurance broker to help you find the right type of coverage based on your business model or technology that you're using. The what, we've already started to get into this, but you want to find a policy that has broad language. Incident reporting language is also important. That means the insured has the ability to report potential claims as soon as they become known to him or her. You don't want any exclusions in your policy specific to licensure or otherwise. And then you can also add certain enhancements to existing policy depending on the type of care you're providing or the business model. For example, you could add cyber liability coverage depending on the technology that's involved. Where you want broad coverage, and if you are providing services outside of the United States, you need to make sure there's protection against international exposure. You need to ensure professional liability insurance. You need to ensure that your professional liability insurance carrier extends coverage to services occurring in multiple states. And why do you need this? To protect against liability losses. Although it's not highlighted on this slide, another thing that providers should consider is having clear and strong informed consent policies in place to help patients understand and acknowledge the potential risks associated with a telehealth encounter. Some states mandate this, but if your state doesn't, you should have one in place. So that's generally a very, very quick overview of the unique liability issues that providers face when providing care via telehealth, some of the jurisdictional issues that are important to consider, and then we just started to scratch the surface on how you can protect yourself against liability. And I think that about does it, Whitney.
All right, great. Well, thank you for joining us, and this concludes today's webinar. You're welcome to submit questions directly to Francesca at fozinal@ebglaw.com or using the phone number displayed. In approximately 2 to 3 business days following the webinar, Epstein Becker Green will communicate the availability of the webinar recording and access to the PowerPoint materials. We hope you will join us for the final installment in this telehealth and telemedicine series taking place Tuesday, July 25th at 2 p.m. Eastern. For additional details or to watch recordings of previous webinars, visit www.ebglaw.com/events. Thank you.